Hi, this is Thaddeus Pope, and this is a recording of a talk that I did this first week in June 2019 in Chicago. Brain death, legal status amid growing uncertainty. So just looking at this patient, it's difficult, if not impossible, to tell whether she's alive or whether she's dead. And unfortunately, it's increasingly difficult to determine that even with a thorough medical examination. And unfortunately, this has happened in a lot of cases that have been litigated in US courts over just the past few years. There's increasing conflict over who's alive and who's dead. We're often unsure, sometimes clinically, sometimes legally, about who's alive and who's dead. But we do need to know. It's important. In a recent amicus brief, the Georgia Hospital Association wrote, determining whether a patient is alive or dead is the most fundamental aspect of providing medical care. So what I'm going to describe in the next 12 minutes is a proposal for a revised Uniform Determination of Death Act, the RUDDA. So here's the roadmap in three parts. First, to recap what is the UDDA. Second, to describe four problems with the determination of death in the United States today. And then to describe some proposed amendments to the UDDA. Okay, so the Uniform Determination of Death Act. This was first published in 1981. It's a pretty short uniform act compared to the dozens of other uniform acts that have been published by the Uniform Law Commission. The UDDA is just 44 words long, yet it's a rather important law. It basically, in US jurisdictions, is the law that legally separates who's alive from who's dead. It's the line that separates life from death. And basically what the UDDA says is that there are two ways to determine death legally. First, by irreversible cessation of circulatory and respiratory functions, the so-called traditional path, or alternatively, death can be determined by irreversible cessation of all functions of the entire brain. So we're going to focus on this second, newer prong, which is what the UDDA added to pre-existing law. It basically says that brain death is death. And this has been adopted pretty much, although with some language variations, in all US jurisdictions. Why was it adopted? Why was it even written? Well, if you go back, right, if you go back to before 1981, before the UDDA, most US states already had legally established that brain death was death. Kansas was first. It did so as early as 1970. So why the UDDA? Well, unfortunately, what happened was during the rest of the 1970s, the several states took 7, 8, 9, or more different approaches to exactly how they formulated the determination of death and what its significance was. And some of the variations were material. So there was massive variability in the manner and consequences of determining death by neurological criteria from state to state to state. And by the end of the 1970s, this was deemed to be intolerable. Uniformity and consistency is very important on a question as consequential as who's alive and who's dead. Thus, the UDDA was designed and then adopted to assure that level of uniformity. Okay, let's fast forward now from 1981 up to 2019. There are 4 problems with the determination of death, and I'm going to describe legal problems and practical problems. There's other debates going on about whether brain death is biological death, and whether the tests are scientifically rigorous enough. These are more legal and practical problems. So first, the thing to say about all 4 of these problems is that they exacerbate variability and uncertainty. And that's exactly what the UDDA was designed to eliminate. So we have exactly the situation that we had right before 1981. First problem, there is a gap between the medical criteria and the legal standard for determining death. So generally, at least for adults, the most authoritative criteria for determining death are thought to be those of the American Academy of Neurology. And they have guidelines, which are the dominant guidelines that they publish. The current ones in force were published in 2010. But earlier this year, in March 2019, the AAN published a new position statement. And this is notable because in this new position statement, the AAN says that a patient can satisfy brain death guidelines, their guidelines, the dominant guidelines. Therefore, the patient is dead. Yet, that patient may still have neuroendocrine function. Neuroendocrine function may be present. In other words, what they're saying is it's okay to declare somebody dead despite functions of the pituitary gland and the hypothalamus. And maybe those functions aren't important, maybe they're not clinically significant, maybe they're not biologically significant. That's not what I'm going to flag. There's a different problem. And this is why this is a dangerous concession by the AAN. Others have been arguing about hormonal functions and neuroendocrine functions for years, but now you have the same organizations that is the author of the guidelines conceding that those functions persist even after satisfaction of the criteria for determining brain death. Here's the problem. The UDDA, again, which is the law in every state in the United States, requires irreversible cessation of all functions of the entire brain. Well, the hypothalamus and the pituitary gland are part of the brain, and therefore the law, with its categorical and demanding standard, would require the cessation of their functions as well as the cessation of other functions of the brain. So there is a gap between what clinicians are actually measuring when they determine death by neurologic criteria and what the UDDA requires before the determination of death on neurologic criteria. Or to say it another way, many of the 11,000 cadaveric donors from whom we procure organs each year aren't dead at the point in time that we procure their organs, right? We're violating the dead donor rule because the dead donor rule is a legalistic rule, right? We want them to be legally dead before we can procure their organs. They may be medically dead according to medical guidelines, but they're not, at least many of them, are not legally dead because they have ongoing functions of some parts of their brain. Okay, problem number 2. The UDDA requires the determination of irreversible cessation of all functions of the entire brain has to be made in accordance with accepted medical standards. Generally, those are thought to be those of the American Academy of Neurology. But the Supreme Court of Nevada seriously questioned whether the AAN guidelines were accepted medical standards. And in fact, what the Supreme Court of Nevada noted were the AAN's own publications on this point, where they observe that there is massive variability of brain death policies in the United States. In publication after publication, in their own associations' journals, like Neurology, say there is a lack of uniformity in brain death determination policies. Hospitals in the United States aren't following the AAN guidelines, right? And they publish about this again and again. So, what's the upshot? Well, there again, massive variability in how brain death is determined in the United States, right? The variability is in terms of the number of physicians. Can one physician do it? Does it have to be confirmed by a second physician? Who are these physicians? Does it have to be a neurologist? Does it have to be somebody board certified in critical care? Can it be any physician? Can it be an advanced practice registered nurse? And there's lots of variation in exactly how the tests are administered. These things vary from state to state. They vary from hospital to hospital. So from where we were sitting when I did this presentation earlier this week, in downtown Chicago, if you were taking a few blocks in one direction to Northwestern, they might determine brain death in one way. But if you were taking a few blocks in another direction in downtown Chicago, they might determine brain death a different way. Moreover, even at a given hospital, 2 different clinicians at the same hospital might not determine brain death in the same way, because there's been some measurement that things vary internally, intra-institutionally, as well as inter-institutionally. Again, massive variability. Third problem, must clinicians get consent for brain death tests? Well, a lot of families are objecting to this. So just give you one case of a number of recent cases that have gone to US courts in the past few years. This is from Montana. This little boy, Alan Calloway, 6-year-old, drowned, although according to his family, almost drowned a few years ago. He's taken to this hospital and they think that he may be brain dead. They administer the clinical bedside tests and now think that he probably is brain dead, and they want to do the apnea test to confirm. But the mother, Alan's mother, objects to that. So the hospital goes to court and says, Judge, we have a patient in our hospital. We need to know whether that patient is alive or whether that patient is dead. Give us permission to go ahead and do these tests. Judge says no. Your request permitting testing is denied. The mother has sole authority to make medical decisions, including brain examinations. And so, answer the question, must clinicians get consent for brain death tests? Well, in Montana and a few other states, the answer has been yes. In some other states, the answer has been no, you don't need consent to do those tests. So we have sort of an almost even split on this question in the United States. Again, variability. Fourth problem, some families want a religious exemption from brain death. They have that already in New Jersey. In New Jersey, for decades, the law has said that death shall not be declared on neurological criteria if that would violate the patient's personal religious beliefs. So if you have a religious objection, you can't be declared dead on brain death criteria. Now, you may satisfy brain death criteria, that might be ascertained and documented, but clinicians may not declare you to be dead until you satisfy death on cardiopulmonary criteria, circulatory criteria. Now, this sort of rule, this exemption rule, has been rejected everywhere outside New Jersey. Now, there have been a lot of lawsuits and a lot of bills trying to replicate the New Jersey rule. Just give you one example of a number of these from the past few years. This is in California. It's recently argued to the U.S. Court of Appeals for the Ninth Circuit, still waiting for a decision, involving this baby and his parents are suing the state of California. And what they're arguing is that we have religious beliefs that so long as the heart is beating, the patient is still alive. And therefore, following the Uniform Determination of Death Act, removal of cardiopulmonary support at brain death is unconstitutional because it interferes with our freedom of religion under the First Amendment. So they basically think that they want an exemption, and they think they're entitled to an exemption, as New Jersey residents are. And we're seeing more of this because there's a resurgence in assertions of conscience-based objections to lots of things in healthcare, both by clinicians as well as by patients and families. And then on top of the exemption issue, we have some states that legally mandate that hospitals provide a reasonable temporary accommodation. So these laws don't change the fact whether the patient is alive or the patient is dead, but they do require that after the point in time of legal death, the hospital continue organ support for some period of time. Again, variability on the exemption accommodation question. So to recap, we have a gap between the medical standards and the legal standards. We have uncertainty about what are the accepted criteria for measuring or diagnosing brain death. We have variability on whether or not consent is required to do the tests to diagnose brain death. And we have variability in terms of how to deal with religious objections. So, variability and uncertainty. The line between life and death needs to be bright and clear and sharp. But right now, it's a bit fuzzy and a bit gray. Right? What we might need to do, as some might say, is to build a wall between life and death. So, these are some proposed amendments to the Uniform Determination of Death Act, right? What one might call a revised Uniform Determination of Death Act, an RUDDA. So first, on this gap, this medical legal gap, one thing to do would be to just exempt the hormonal function, right? To write that into the statute to clarify and to confirm that those functions of the brain don't count. They're not relevant, right? So to change the current law, which requires the irreversible cessation of all functions to be the irreversible cessation of all functions except hormonal functions. Second, on this idea of what are the accepted medical criteria, write them right into the statute, right? This is what Nevada did a couple years ago, right? If you think that the AAN guidelines are the accepted medical criteria, but there's some uncertainty, then just reference them by name in the very text of the statute. Third, on this idea of the consent requirement, there's variability on that question. That can be resolved as it was resolved in Nevada by adding language right into the UDDA, which says that, well, you should make reasonable efforts to notify a patient's next of kin, but consent is not required for determination of death. And then finally, on the final question, the religious exemption question, this may be more difficult. There is just massive variability on how related questions are dealt with by the several states. So to incorporate a prescriptive pathway in a uniform act might be too much to hope for. So the recommendation would be, at least for the several states, to provide clear legal guidance on whatever their rule is. If you're going to offer an exemption, be clear about what the exemption is and when it's available. If you're going to require accommodation, again, just be clear what is the duty, is there a duty, and what is the duty. So that the recommendation is just to clarify what it is, but not to prescribe a particular pathway. All right. So I'm Professor Thaddeus Pope, and that's Brain Death and the Revised Uniform Determination of Death Act. Thank you.